Hi, everybody, and welcome to the open house for the University of Ottawa Faculty of Law Common Law section for 2022. My name's David Wiseman, and I'm an associate professor in the faculty and currently serving as the Vice Dean academic of the English Common Law program, which means I'm primarily responsible for organizing the teaching program each year. And I'm joining you from one of our classrooms. It's not as funky as the Gathertown Auditorium, but it is real. This is room 302 in Fauteuil Hall, and so I'm joining you from the main campus from Ottawa itself. And of course, that means I'm joining you from unceded Algonquin territory. And I wanted to commence today's event with the University of Ottawa's Indigenous Affirmation Statement. So we pay respect to the Algonquin people, who are the traditional guardians of this land. We acknowledge their long-standing relationship with this territory, which remains unceded. We pay respect to all Indigenous people in this region from all nations across Canada who call Ottawa home. We acknowledge the traditional knowledge keepers, both young and old, and we honor their courageous leaders, past, present, and future. And as you would probably know from your own experiences, part of the point of doing an Indigenous affirmation or land acknowledgement, as they can otherwise be framed, is not just to say it, but to reflect on what it means institutionally and individually. So I wanted to just point out to you that institutionally, as a law faculty, we are committed to reconciliation and decolonization and advancing those. And in your program booklet today, you can see the pathways statement of the Faculty of Law, and so I refer you to that. If you enter first year here at our faculty, then you will be studying Indigenous legal traditions and the law as it affects Indigenous communities in Canada in your first year courses and beyond. At the moment, that content is embedded in a lot of first year courses, and we're currently developing a pilot to enhance that content for the coming year. Individually, I am also a bit involved in trying to advance justice for Indigenous peoples. I teach an upper year Access to Justice lab course, and as part of that, some students have the opportunity to participate in an Indigenous human rights clinic program that runs here in Ottawa and has a sister program in Toronto. So we're committed to advancing that as an institution and in our own individual professional work here. So again, welcome. And at this point, I wanted to hand over or let you meet our interim dean, Alain Roussy.
Welcome to the 2022 edition of our open house. If you're here today, it's because you've received an offer from us, and perhaps you've already made up your mind, or perhaps you're still in the process of making up your mind. So one way or the other, I hope to convince you, and not just me, but everyone else that you're going to hear from today. We hope to convince you that you either have made the right choice or you are about to make the right choice in joining us in September of 2022. So it's really I'm really happy to take part in this open house this year. So let me just take a few minutes to just highlight a few things that I think are relevant for your consideration as you embark upon this very important phase in your education in terms of choosing your law school. As you probably know, we here at the University of Ottawa have been around for 60 years, well, over 60 years now, and we are indeed the biggest law school in Canada. And obviously, being big sometimes comes with its difficulties, or it comes with its additional burdens sometimes, but it also has so many advantages as well. So I just want to talk a little bit about some of those advantages that I think are relevant for your consideration. We at the University of Ottawa have so many courses to choose from, because being big means being big in terms of student numbers. It means being big in terms of professors, and that also, that translates amongst other things in terms of being able to offer a really wide variety of courses. Obviously, our first year curriculum will resemble what other law schools are offering, although with a bit of a twist on the English side. You do have quite a few courses to choose from, even in your first year as one choice. But going forward in year 2, in year 3, there really is a very wide array of courses to choose from. It also means that we have here, amongst our many, many professors, various leaders in multiple fields. And I'm talking about Aboriginal law, environmental law, health law, immigration and refugee law, international law and international trade, business law, human rights law, technology law, public law, and social justice, amongst others. So those are only a few of the really areas where I think that we stand out. And it's not just standing out, me as dean saying, oh, I think we're good in those things. We actually have, for at least a few of these areas, very specific centers and centers of research. So for example, we have here at the University of Ottawa, the Center for Law, Technology and Society. We have the Center for Health Law, Policy and Ethics. We have the Center for Environmental Law and Global Sustainability. We have the Refugee Hub, and we have the Public Law Center, and we have the Human Rights Research and Education Center. So those centers, obviously, it's not just a one-person operation. If we have those kinds of centers, it's because we have a critical mass of our professors teaching and researching in those areas. Another area, I think, where being big is actually a good thing is in terms of the experiential learning opportunities that we can offer, which includes clinics, and it also includes mooting events that we take part in as part of the curriculum. So in terms of experiential learning in clinics, we have a number of clinics here on campus that you can join as a student and really hit the ground running in terms of getting your hands dirty and really dealing with actual files. So for example, we have the community legal clinic that deals with criminal and civil matters. We have the Samuelson Glushko Canadian Internet Policy and Public Interest Clinic that deals with public interest disputes involving technology. We have the Eco Justice Environmental Law Clinic, which deals obviously with environmental policy and environmental litigation. So those are just three examples of the types of clinics that are being run out of the law school here and that you as students can get involved in. As I said, we also take part, as Canada's biggest law school, we also take part in a number of mooting competitions. So these mooting competitions are kind of mock trial competitions, if you will, and there are a number of regional ones, provincial ones, national ones, and international ones. And in the last many years, this has really become something where the University of Ottawa shines. We are the leaders in mooting competitions in Canada. Another thing I want to just touch briefly upon is the obvious fact that the University of Ottawa is based in Ottawa, and that comes with its own advantages as well. We are a stone's throw, or well, perhaps a little bit more than stone, but let's say a 10-minute walk from Parliament Hill here. We're maybe a 10 to 15-minute walk from the Supreme Court of Canada, and that that's not just fun to say. Obviously, it's fun, and if you want to have access to, say, a Supreme Court hearing, for example, you'll be able to walk there in 15 minutes and listen to it. But it also has other implications as well. So, for example, in non-COVID years, we often have as part of our orientation, we often have a welcoming ceremony on the lawn of the Supreme Court. That's not obviously something that is possible in another law school. We also have very close ties with the Supreme Court. So for example, this year, in a couple of weeks, on March 22nd, we will be hosting a welcoming ceremony for Justice Mahmoud Jamal, who was appointed, so the newest appointment to the Supreme Court. He was appointed last summer. And this is a tradition at the University of Ottawa where we welcome the new justice. And usually for those kinds of welcoming ceremonies, the whole court comes. And so all 9 justices will be coming to the court very shortly for that welcoming ceremony in a couple of weeks. So that's just an example of the type of things that are quite unique here at the University of Ottawa, just this being positioned here in the capital. And the last thing I'd say is the University of Ottawa as an institution, and we here at the Faculty of Law, are both bilingual and bijuridical. And so if you've had some French language education in the past and would like to continue upon that route and take a few courses, for example, in French, we have a PCLF, Programme de Common Law en Français, and therefore you'd be able to take, if you want, some courses in French in common law. We also have our sister section, the Section de Droit Civil, who offers, so they offer a number of courses in civil law, and folks who go into that program can complete their civil law degree. And those courses, again, are accessible to you if you want as common law students. So it's a rather unique place to be. I think as you consider your options, if you haven't yet made up your mind, as you consider your options for law school. So those are just a few of the points that I wanted to touch upon, and I'm sure during the day today you will be hearing a whole lot of other great reasons why the University of Ottawa is special. So again, welcome to the University of Ottawa. I hope you will have a great day. I hope that you will learn a lot, and I hope that your questions will be answered. So certainly do not hesitate to reach out to me or to anybody else in terms of professors or staff if you have questions about the choice that you have made or the choice that you are about to make, so don't hesitate to do that. So I look forward to seeing you in September. Bye for now.
Okay, thanks, Alain. Could I just make an announcement about your participation? If you're watching the broadcast in GatherTown, could you mute yourself? Just because that can make for the best experience for everybody, rather than having other noise coming through. Okay, so thanks for your patience this morning as you're waiting for us to get going, and I hope you're enjoying this this GatherTown experience. And I'll have a bit more to say about how we came to be in GatherTown together a little bit later. And we're of course sorry that we can't be with you all in person today as we have been in previous years, but of course for obvious reasons that's not possible, but thanks a lot for joining us today. Or this morning. So you should have received a booklet with information about today's agenda. And so now that we've heard the welcome from the Dean, we're going to move on to a keynote speaker, and then who's going to speak for 20 to 25 minutes or so. And then I'll come back and introduce a panel to you. A panel of faculty members who are leaders in their field, who will share with you information about the sorts of things that they do around the faculty. So at this point, I want to introduce Deborah Love, who's an alumna of the faculty and legal counsel at Department of Justice Canada, as well as founder of Intention First. And there's biographical information about all of our speakers today in the booklet that I've mentioned, and there's more information about Deborah there too. I'll just tell you a little bit about her. Deborah Love is a lawyer whose work in government over the last 10 years has spanned a variety of areas, including international law, administrative law, commercial law, and privacy law, while having advised in a range of other areas such as finance, IT, security, and human resources. As legal counsel in Aboriginal law with the Department of Justice Canada, Deborah specializes in negotiations and dispute resolution, advising on self-government agreements and treaty implementation and litigation support. Deborah also, as was mentioned, is founder of Intention First, and she's been an educator, speaker, and advocate of well-being, diversity, and success for over 15 years. So we're really proud of Deborah and so happy that she could join us today. So now I'll pass it over to her.
Hello, future University of Ottawa law students, and congratulations to you on everything you've done already to get to this point in your life and get to this point on your path to attending law school. This is a brand new door that's open for you, and I, for one, am very excited for you. And as an alumna of the University of Ottawa and legal counsel of the Department of Justice, as well as the founder and CEO of my own company, Intention First, I'm honored to have this opportunity to be invited to speak with you and share some reflections with you on finding the life that works for you with law. There are so many paths and opportunities and possibilities, and I'm very happy to be able to share with you why I chose the University of Ottawa, why I chose to go to law school, period, and why I chose the University of Ottawa, and where my career has led me with my law degree. And then I'll just wrap up with, how you can set yourself up for the most successful future, no matter what path you choose to take with your law degree. And like I said, there are many. So first, I want to talk to you about this brand new door that's open to you. And the first thing I want you to try to do is imagine for a moment that it's first thing in the morning and you're just waking up. And as you lay in bed, your eyes still coming into focus, you glance over to your bedroom door and see a brand new door. The door is slightly open, inviting you to walk over and go through it. And you wonder, what is this door? How did this happen? Some of you may feel completely excited and just jump out of bed and run over to the door and want to go through it and explore. Some of you may feel panic, bewildered. You may wonder how that door got there and what could be on the other side. And some of you may just want to disappear. You may want to close your eyes and imagine if the door is still going to be there when you open your eyes again. And all of those feelings are valid. Every one of you can be feeling something completely different. And this door that's open to you, this law school opportunity, that's a big deal. And people may be expecting you to feel excited or expecting you to feel nervous or expecting you to feel proud. People may have all sorts of expectations about how you may be feeling right now, how you may be feeling in this moment, and how you might be feeling on your path. So just take a moment now to just recognize how you might be feeling. Recognize who you've been sharing this experience with and sharing this possibility with, and just also know that anything that you're feeling is completely okay. And you don't have to be feeling what people are expecting you to feel. You could feel nervous rather than excited. You can feel excited rather than nervous. So just know that so many people are feeling so many different things, and this same experience will continue as you go through your law school path. So that's not going to end here. This is just the beginning. And that's one of the key things that I want to share with you on this journey to going through law school and to going through whatever you decide to do. Keep owning how you feel. Keep owning the experience that you want to have. And I called my company Intention First because that's the first thing that matters. What exactly is it that you want for yourself? And what made you decide that you wanted to go on this path? Did you decide, or did you just happen on this path? Did you stumble? Was it, so many people go to law school for different reasons, and nobody's reasons are exactly the same. Some people want to make money. Some people want to make a difference. Some people want to impress their family. Some people want to impress others. So there's a whole host of reasons that you may have chosen or not chosen or ended up here. So that's something really important for you to be able to consider as you continue to go through this path of law school, because there's so many things that can happen on this path. And so for me, I decided to step through that door of law school, that door of my future. A few years now, I think, when did I go to law school? In 2008. And I was already working. I was a mature student. I decided to apply sort of on a whim. I was working already at the Department of Justice. I had an entire career before. I had made it pretty senior in my career, and I was looking at different options of what I wanted to do with my life. I'd worked in change management and HR. I was a senior learning advisor and strategic learning advisor and change management consultant within the department. And so I was working with many senior lawyers at the time, sort of on a first name basis with lawyers. And going to law school for me was a bit of an identity shift, coming back, restarting law school. And I was still taking notes by hand, and I wasn't familiar much with the computers, and I had to buy a laptop. So there's generational things. So one thing that I want to tell you, especially for mature students or for new students, everybody comes to law school with different backgrounds and different advantages and other things that they have to work through. So you can't say that someone who's just graduated is necessarily more prepared than someone who's had a lot more life experience. So I just want to put that marker down for people, for regardless of what your background is, however you've come to law school, however you've shown up here. If you're in common law, and you are, if you're in common law, you've had an undergraduate degree, those degrees can be in any number of things. So some people have a strong background in writing. For example, if you did English Lit, some people have a strong background in very concise theoretical step-by-step thinking. For example, if you did, I don't know, engineering, or if you're in some kind of thinking medical, biological, if you've had some background like that. So people have very different backgrounds, and I want to say that use your background to your advantage and also know where its limitations are. So for example, if your background is in something like chemistry, and you're great at working in labs and being a linear logical thinker and one step after the next, you may, for example, like copyright law, something like that, which is, or patent law, which is more sort of step by step. There's different areas of law that you might explore based on that background, or if there's specific things that you like. And so those are things to consider. And you might also think about the fact that your writing may not be as strong. So you might want to bolster that area of learning and learn more about how to write and do more practicing like that, especially if you're going to be writing exams. The first year is mostly exams. It's not a lot of essays. And so that's the other thing that you want to decide as you're moving forward in second and third year, not so much for first year, but do you want to have more essay-based courses? Do you want to have more exam-based courses? So those are choices you're going to be able to make in upper years and tailor that a bit to your interests and your strengths. I chose also to practice to study in the Common Law and French program. I was fluent in French, but it was rusty, I have to say. But I knew that I was already working for the government, and I knew that I wanted to have a public service government career. And so being bilingual was pretty important. Even if you're not practicing all the time, if all your files aren't going to be in English and French, it's very useful to have that background in French. I did know immediately that I wanted to practice in English and French. And so I did the Common Law and French program. If you're familiar with it, or if you're in that program, you know that it's not optional to do all of your papers and your exams in French. In the English Common Law program, there's a difference. You can write in English or in French, I believe. It's still the case. Your exams and your papers, that was the case when I was there. But like I said, in the French common law, you couldn't. I think in the second and third year, the upper years, you could do 25%, so maybe one course a year in English. So those are just a few things to think about. Where do you want to practice? Where do you think you want to practice? If it's with government, maybe you want to consider also doing a course in French or writing an exam in French, even if it's not your main practice. So there's lots of those considerations you can think about. I also decided to go to University of Ottawa. That's one of the reasons, so that I could do the Common Law and French program, but also because it's near Parliament and the Supreme Court, and you can actually go there and take tours and find out more about it and actually be in the presence of those things. You can watch the cases that are happening, and that's a very unique opportunity that happened while I was there. I guess now it's being virtual. I think a lot of it's virtual. Maybe it's more open to other people, but it's still really a great thing to actually be in that environment, to go look around the walls and see all the people, the predecessors who were there. It's a great experience to be there. I'd also say, when you're at Ottawa U, there's a lot of great clubs and committees that you can be a part of, that you can be a leader of. So those are really great things to be able to explore in addition to just doing your classes. Speaking of explore, I just don't want to forget travel. So I traveled to France and Israel as part of my law school. I did France in part because I was in the common law and French program, and I needed to do my studies in French. And so by doing my international law, which is one of the areas that I was really interested in, by doing some international law practice in France, I was able to still do my credits in French and be able to travel. So if you're interested in traveling or exploring, be aware that that's a really great possibility and opportunity here at Ottawa U, and take full advantage of that if it's possible still in this time. So I would say look for that for your second and third years. Obviously, the first year is a lot to handle, and it's a lot, it's an adjustment, right? A transition. So the first year is really focused on the studies that you have, and then the second and third years are really great times for exploring and doing other things as well. But I would say throughout your entire legal practice and your your law school adventure, I would say it's really useful to have and keep your outside activities. Keep something in your life that is not about law school. You will really thank me for that once you get into your first year and you're not showering, or you're doing your exams and things get really, really crazy and hectic. Keep outside activities. Keep something that you love, other hobbies. Make sure you keep those going. So important. And also, I would say, make sure, be open to trying different things. Some of you may be that person who's like eager to walk through the door because you know exactly what you want on the other side. You've decided you wanted commercial law practice, you know exactly what you want to do. Maybe you know someone who's already doing it and you have a path towards that. That's great. It's really good to have that knowing and to go straight for that. However, it's also really important to just understand how the practice of law works and know other aspects of the practice and get to meet people in other communities, because that will also be of great service to you and great value to you. And so take a moment to just try out a course that's outside of something that you would normally do. And I would say that for both people who know what they want and for people who don't know what they want, that's entirely fine. This is an opportunity to explore in those second and third years. First year is not exploration. First year is pretty clear cut. You're given your courses, there's stuff that you have to do. Try to get just, and just make sure that you keep those outside activities, that personal hobby. And then in upper years as well, take advantage of the clubs, take advantage of panels that happen, take advantage of everything that you can outside of just having the formal classes. And I'll say that my career has led me, so this is just moving into the next part. I walked through the door and I did law school, and I wanted to spend most of my time for the talk on that because that's where you are now. I would say those future considerations about, you know, practice and articling, and those will come later. But just to give you a bit of a sense of where your law school can take you, my career, I've worked exclusively at the Department of Justice. But working at the Department of Justice, it's huge, right? It's a department of about 5,000 employees. They're all over the country. So there's opportunities to work in different areas of practice. So I've worked in I started in international private law. The actual international private law group doesn't exist anymore. It's bridged, but that was what the area of practice that I wanted to do, the international private law and dispute resolution. And I was so fortunate to be able to be hired back in that area that I really wanted to practice in. Then I discovered that I didn't actually like the practice. I liked the idea of it. I liked the area of law, but the practice was very different than I anticipated. So that's why it was really good that I explored different areas of law while I was in law school. It gave me an opportunity to try out other things. And so in my legal career, I've also practiced in corporate and commercial law. I've done employment law, privacy law, administrative law. Currently working in Aboriginal law, which was a great culmination of the various different types of experiences and practices I had, because in Aboriginal law, it's very complex by its nature. You're dealing with contract law or treaties, implementation, development. I'm personally working in negotiation in Northern Affairs, which deals with negotiation, self-government agreements and treaties. So there we're looking at both, you know, environmental law, land-based, land and resources, asset transfer, jurisdictional issues. So it combined a lot of the different areas of practice that I was interested in and that I did prior to this. And I had no idea that I would ever end up in Aboriginal law. So that's just another indication for you that you just can never know for sure exactly where you're going to end up or what actual practice you're going to love. So try things out, have fun, try to have fun. Don't let it all be stressful. Law school can get to you in the sense that you want to go do well. Some people know that they want to be at the top of their class. For some people, it's a bit of an awakening to not be at the top of the class because there's, you know, it's not possible for everybody to be at the top of the class in law school because the grading system is a bit different than in undergrad. So what you want to look at is what exactly are your goals that you want to get out of law school. If you know that you want to clerk at the Supreme Court or the federal court, typically that requires you being at the top of your class to go through the process of your application and getting in. So if that's what you know you want and that's where you want to go, well, you have to focus a little bit towards that. But if that's not the thing that you think you want, if what you want is a law degree and what you want is to be able to practice in a certain area, your grades only matter for a certain time and for certain reasons. So, you know, that's something for you to be able to consider and think about how you want to live your life and not just your grades. So one of the things then that I'll say in terms of setting yourself up for the best possible life and practice, regardless of the path you choose with your law degree. One of the biggest competitive advantages that you can have that people don't really tell you, or that you don't really understand until you actually have it, is wellness. Actually being happy and healthy and stress-free, limiting your stress as you move through this. Actually learning the practices of meditation, mindfulness. There is so much value in that. People start to think of it as, you know, people have said, or especially in some areas of legal practice, you know, it's a growing field now, it's a growing area, especially as we talk about mental health and well-being. But it wasn't something that I had the opportunity to take while in law school. And now that it's growing, if you have the opportunity to be a part of that and to really understand how that can benefit you, it is a big secret that being well and actually taking care of yourself builds your capacity to do better, actually getting sleep, actually eating well. All of those things really help you to be able to think better, to be able to perform better on your exams, be able to perform better in your thinking, be able to do better in your mood, or better advocate. So those are things that now the field is growing in terms of understanding how the health practice and how taking care of your well-being at the same time as doing exams or trying to perform well, how it actually impacts your performance and helps you to be more successful. So for those of you who think that law school is just all about, you know, not sleeping and squeezing every single hour you can, every single minute into studying, you know, this is an opportunity to really look into how you can use a well-being and a healthful approach to your success in law school and your success beyond law school. I started teaching lawyers at the Department of Justice. I started teaching them yoga and do wellness practices, meditation and mindfulness. I started doing that sort of off the side of my desk while I was practicing, and building that opportunity for lawyers to actually experience well-being in the legal practice. And it's shifted a lot of people's lives and made them be able to perform better. And so one of the things that I really, really recommend is being able to resource yourself in ways that support you moving forward, no matter what path you choose. So I think on that, this is a time where I would normally talk to you about questions that you have and see what specific experience you're going through. But what I would say is I can't think of any downside to actually going to law school. It opens really many, many doors. So that first door that we talked about, that's the first door that you're just walking through. And behind that, what you can't see is how many other possibilities there are just waiting for you. And no one person needs to go through all of the same door. So there's so many different opportunities that there's something perfect for every single one of you. So stay on your own path, stay in your own lane, just recognize what's important to you. It's not the same thing that's important to everyone else, and do what really fills you up, really what lights you up, and actually give that some consideration and stay on that path. And in the end, the open door awaits you. Enjoy your life, enjoy your legal practice, enjoy your legal career, enjoy whatever you choose to do with your law degree. Whether you decide to practice law or you decide to open your own business that has nothing to do with law, it still informs your ability to do anything, to have this knowledge, to have this critical thinking, to have these skills and this training that allows you to understand and see the world in a brand new way that's not afforded necessarily to people who didn't have this experience of law school. So understand that that already gives you another competitive advantage for your life and for whatever you choose to do. And so I wish you everything good. I wish you all the success in whatever your choices are, and let your intention lead the way for your life, and have a really wonderful experience.
Thanks very much, Deborah. And I hope you all found her messages to be useful. I think there are some bunch of important points that Deborah made as you're considering, your future in law school, whether it's with us or elsewhere. We hope it's with us, but lots of things to think about there, and that hopefully will give you food for thought as you're making these decisions and however you choose to proceed. I'd like to just pick up on the point that Deborah made about exploring things when you're in law school. And the next segment that we're going to, which is the panel of professors who are going to talk about their work and areas that they're involved in. Part of our intention in putting together this panel is to show you the range of things that we explore as a faculty and students, and that you might choose to explore and sample when you come here. So we've got presentations from 7 colleagues who are each going to speak for about 5 minutes about areas that they're involved in, and I hope you find that interesting. Then after that, we'll conclude this part of the session and move into the virtual fair. So we're probably looking, it'll be about half an hour or so before we move to the virtual fair, and I'll say a little bit more about that before we move into that. Okay, so now I'll pass over to our panel, and I believe our first speaker is Professor Linda Collins. Again, in the program, there's the list of speakers and the topics that they're going to address. And I should also point out that in the program, Deborah mentioned a lot of things about sort of how our program works and what opportunities are available to you. And there's a lot more information in the booklet as well about that. And of course, you can find out more at the virtual fair. Okay, sorry. Now I really am going to pass it across to my faculty colleagues.
Hi, my name is Professor Linda Collins. I've been on the faculty in common law for about 15 years now, and I'm an expert in environmental law, in particular rights-based approaches to environmental protection. And so I wanted to talk today about ecological constitutionalism, or the idea of integrating ecological needs and imperatives into our Constitution. When I graduated from law school more than 20 years ago, those two fields of constitutional human rights law and environmental law weren't really talking to each other. So we had a very robust, active environmental law community, lawyers who were drafting important environmental legislation at the federal, provincial, and municipal levels, lawyers in the public interest bar who were litigating important environmental cases, and lawyers in the toxic torts bar, sort of the Erin Brockovich branch of environmental law, who were actually suing corporate polluters directly on behalf of injured plaintiffs who had been harmed by pollution. On the other hand, we had a very active human rights law community who were involved in developing and implementing human rights codes at the federal and provincial level, in litigating human rights cases under those codes, and of course under the Canadian Charter of Rights and Freedoms. and lawyers who were active in the international human rights movement. But we didn't have in Canada at that time, 20 years ago, much of an understanding of how human rights and environmental protection are linked. And it is a relatively new idea. Internationally, the idea of the right to a healthy environment first shows up in an instrument called the Stockholm Declaration in 1972. And after Stockholm, we witnessed around the world what Professor David Boyd has called an environmental rights revolution, where countries all around the world began to incorporate the right to a healthy environment in their own constitutions. And ultimately, it culminated back in the International Forum in the fall of 2021, when the Human Rights Council recognized the right to a clean, healthy, and sustainable environment as a basic human right. So what about in Canada? Well, we are still a little bit behind. We are one of the few countries in the world that doesn't have an explicit right to a healthy environment in our Constitution, and has not yet had a judicial finding that existing rights include their environmental prerequisites. So countries like India and Pakistan and elsewhere have recognized that their constitutional rights to life, etc., encompass the right to not be deprived of those entitlements through state-permitted or state-caused environmental harm. We don't yet have that in Canada. However, you are coming to law school in an unprecedented and exciting period in Canadian legal history in this respect, because we currently have several cases before the courts working their way through the system that are arguing that climate change in one case and mercury poisoning in another violate the applicant's rights under our charter, the rights to life, liberty, and security of the person under Section 7, and the right to equality under Section 15. The equality argument is based on the fact that these applicants are either youth in the case of the climate change cases, or Indigenous people in the case of the mercury situation. And we had a huge breakthrough also in the fall of 2021 when one of those climate suits survived a motion to dismiss. So this is where the defendants go to court and say, this claim is so weak, it shouldn't even go to a full hearing. It should be tossed out early. And in that case of Matur versus Ontario, the Ontario court held that actually it's possible for the government to violate charter rights through its environmental acts and omissions. And that was for the first time in Canadian history. So as you work your way through law school, you are going to be witness to the unfolding of this incredibly powerful moment where we learn that our Constitution can in fact protect the ecological sustainability of our societies and ensure the fundamental human rights of all of us. Thank you so much.
Hi there, my name is Paul Daly. I'm the University Research Chair in Administrative Law and Governance, and I teach Administrative Law in English and in French in the JD program. So what is administrative law? Fundamentally, administrative law is about studying the powers of the administrative state. Where do they come from? Where does the federal government get the authority to declare a state of emergency? What are the preconditions that it has to meet? What are the powers that it can use? Does it have to act procedurally fairly before it freezes bank accounts or makes sweeping emergency measures? What about seizing the assets of foreign officials who are supportive of evil or corrupt regimes? Where do those powers come from? How are they exercised? If they are reviewed in the courts, how will the courts assess their exercise? What are the remedies that are available to individuals who have been wronged by the administrative state? When discretionary powers are exercised, for instance, by ministerial officials who make humanitarian and compassionate exemptions from some of the harsher rules of immigration law, what are individuals entitled to expect from the decision makers who make fundamental life-altering decisions? These are the questions which we look at in administrative law and which you will find some answers to. And it is important to have a grasp of history. History in the sense that the administrative state has grown enormously since the Industrial Revolution and the birth of modern Canada, through the First and Second World Wars and the Great Depression, to the huge welfare and regulatory state that we know today, even with its wings clipped to some extent by deregulation in the 1980s and 1990s, and the rise of a phenomenon known as the new public management, which emphasized efficiency and effectiveness in governmental operations. History, too, in that the control of the administrative state was first developed, in fact, in the courts in England in the 16th and 17th century. And those means have expanded greatly in recent years. Over the last 4 or 5 decades, judges have become very creative in developing the rules of procedural fairness and substantive reasonableness, and using remedies to make sure that administrative decision makers in the administrative state act within the powers that they have, use those powers in a procedurally fair way, which is rational and which furthers the objects which they were given in the first place. So administrative law is a historically grounded study of the vast powers of today's administrative state, and which covers topics which are always in the news. Today it's states of emergency and seizing or freezing foreign assets. Tomorrow it will be something else, but it will always be of great relevance.
Hi, everybody. My name's Colleen Flood, and I'm a University Research Chair in Health Law and Policy, and the Director of the Centre for Health Law Policy and Ethics. Thrilled that you're thinking about coming to join the Faculty of Law here with us at the University of Ottawa, and I really hope you make that choice. My area of expertise is health law, and I work on a wide variety of topics, including issues to do with artificial intelligence and the intersection with law and policy. But I've also been doing a lot of work through the pandemic on law and relating to the pandemic, including around vaccine passports and vaccine mandates. So, you know, we don't hesitate to wade into fairly controversial areas from time to time. And so with the issue of vaccine passports, you know, initially designed so that people would have to show proof of vaccination when they went into congregate settings like a pub or a bar. The idea was twofold. One, to protect people in those spaces so that when you take your mask off to have your meal or have your drink, that it's less likely, because you're vaccinated, that you transmit the virus to somebody else. And then the second purpose was to really incent, or, you know, it's not a great word, but to encourage people to get vaccinated, those who may have been a bit more hesitant, to push them over the line, to take the time to go get vaccinated, to get our rates up so that we can protect our hospitals. So, of course, you know, the question arises, vaccine passports as they were designed, is that constitutional? And of course, we heard a lot of ink dropped and voices raised by people opposed to it on the grounds that it was in contravention of the Charter of Rights and Freedoms. So we've written a lot about this. And if you Google myself and my colleagues, you'll see some of the work we've done published with the Institute for Research and Public Policy and CD Howe and other places. But essentially, the Charter of Rights and Freedoms is not absolute. So, for example, Section 7 guarantees the right to life, liberty, and security of the person. A right to attend a pub or a baseball game, I think most people would agree, after a bit of analysis, that that's not included within the rights of life, liberty, and security of the person. And even if it was extended to that, then the claim is not finished there. One then has to proceed to whether or not it is in accordance with the principles of fundamental justice, which has a wide and long test laid out through various court judgments about how we approach that question. And then finally, whether it's in accordance with Section 1 of the Charter, which essentially says that if it's a reasonable and free and democratic society for government to take that action, then notwithstanding that you might have had a claim under security of the person or another heading of the Charter, if the government is able to persuade the court that it really was reasonable and proportionate in all the circumstances, given the effect of the vaccine on transmission, the importance of protecting our hospitals and our public healthcare system, then the court will weigh all that evidence and decide, as we thought it would, that vaccine passports are in fact in compliance with the Charter of Rights and Freedoms. I just want to emphasize that it all depends on the evidence, right? So the science has shifted and changed. So what was true when we did that analysis might not be true as we deal with new variants which have different impacts on the vaccines and so on. So anyway, that's this little dose of law and vaccine passports. So I hope you enjoyed it. I hope we get to meet you in the incoming class, and take care, and we'll see you soon.
Hi there. I'm Carissa Mathen. I'm a professor here at the Faculty of Law, and I'd like to welcome you to Open House 2022. I've been asked to speak about a current research project that I'm working on. Mine sits at the intersection of constitutional and criminal law. It deals with a concept called arbitrariness, which is very important in both fields. My interest in this topic, believe it or not, was sparked by a controversy some years ago over the offense of polygamy, namely the conditions under which it should remain a crime in Canada. Different concerns had been raised about whether the offense of essentially being in a plural marriage was an infringement on freedom of religion or presented a problem of vagueness in how the law was actually defined. To me, those critiques, while they had merit, they obscured a more essential question, which is, what's the basis on which we should be criminalizing polygamy at all? What is it about that behavior that warrants singling it out among all the other kinds of personal relationships where people might suffer harm? And the more I thought about it, the more I reached the conclusion that there's very little to warrant singling out polygamy in that way. And in fact, the decision to do so, which has been with us for a really long time, is arbitrary. Now, to ask the question, why should we care about arbitrary laws, is to answer it. Arbitrariness matters deeply to the rule of law, which the Supreme Court has defined as excluding arbitrary power. Certainly, it seems non-controversial to say that any kind of arbitrariness in the lawmaking, or certainly in the administration of law, is highly problematic. We expect people who make law to approach that task with reason and care. Arbitrariness seems to denote the very opposite of that, a lack of rational thought, to be inimical to the public good. Now, a decision can be arbitrary even if it's deliberate. And so in this paper, I'm not using arbitrariness to denote a lack of all reason, but a benchmark for the kind of reasoning that should count as a part of legitimate rulemaking and the kind that should not. The objectionable nature of arbitrariness is really intensified in criminal law. Criminal law, which uses force against citizens as a form of punishment, demands a high level of justification. Punishment has been described as a special kind of harm that needs special reasons. Those reasons are found in the kind of behavior the criminal law targets. Some of that behavior may pose a special risk of harm to others. Other kinds of behavior may constitute a public wrong that offends the community's values, what we might characterize as its morals. In the case of this second category, the criminal law is expressing moral values. But those values can be very challenging to articulate in principled ways. Some criminal laws reflect taboos, deeply repugnant practices. They appear to have always been with us. Here we might think of offenses like necrophilia, gross indecency, incest. Until maybe 10 or 15 years ago, we might have placed certain forms of sodomy on that list. In the past, criminal law scholars relied on feelings of disgust and shame as sufficient evidence that certain behavior is beyond the pale and deserves to be punished. Now, some things clearly are taboo that may nonetheless be justifiably criminalized, but caution is warranted when we confront modern versions of long-standing criminal laws. We should be prepared to examine the reasons for those laws and to evaluate whether they still have a place in our society. These are the laws that my suggested approach to arbitrariness is intended to help deconstruct. Now, the current legal test for arbitrariness in Canada is a little technical, but at its root, the test asks whether the law is essentially irrational. My project aims to reset that legal framework, especially when it comes to considering arbitrariness in the criminal law. The criminal law in Canada is a complex system of laws and practices, including one statute, the Criminal Code, that actually dates back to 1892. My argument is that to avoid arbitrariness, a criminal law must not be so out of step with other criminal laws that it cannot coexist with them in the same legal universe. Thus, for example, to go back to the offense of polygamy, the argument would be that basing a criminal prohibition on the mere fact that more than two people are in a marital or marriage-like relationship is completely out of step with how the criminal law approaches questions of harm within other relationships. There, we demand some proof of individual harm. The substitution in polygamy of a numerical benchmark for harm is what renders it an arbitrary offense. It gets pretty complicated, and I am definitely still working out some of the kinks, but if it proves successful, this argument could have a serious effect on the constitutional guarantees that apply to Canadian criminal law. And my hope is that ultimately it would lead to greater justice in the criminal system as a whole. I hope that was of some interest. Once again, enjoy the open house, and I look forward to meeting some of you next year in my con law or criminal classes. Take care. Bye-bye.
It's wonderful to have this opportunity to speak to all of you as you consider your choice of law school. My name is Penelope Simons. I'm a professor here at the University of Ottawa, and I am the Gordon Henderson Chair in Human Rights. I'm also a member of the Human Rights Research and Education Center. I work in a fascinating area of law called business and human rights. It's an area that intersects with many areas of law, including international law, such as international human rights law, international trade and investment law, as well as domestic law like labor law, tort law, corporate law, constitutional law, criminal law, and food law, and so on. A lot of my research focuses on how to effectively regulate resource extraction companies, mining, oil, and gas companies, and coal companies that operate transnationally, and to ensure that they don't violate human rights or cause harm to the environment, and about how to hold them accountable if they do, including providing access to remedies for those who've been harmed by such activities. The regulation of transnational corporate activity, and specifically resource extraction, is something very important for Canada because our economy relies so heavily on resource extraction. We are host to a majority of the world's largest mining and exploration companies, as well as some major oil and gas companies, and many of them operate outside Canada in countries around the world. These companies raise billions of dollars on Canadian stock exchanges, and our pension plans also invest in, including the CPP. Now, few people know that Canadian extractive companies have been involved in some terrible violations of human rights and environmental impacts in their overseas operations. These include things like forced displacement, violent repression of peaceful protests, murder, violence against women, including gang rape, violence against human rights defenders, forced labor, slavery, and torture. It's extremely difficult to hold companies to account for violations of human rights in which they become complicit or in which they perpetrate in other countries. The international legal system is structured in order to facilitate and protect corporate activity, not to regulate it. And Canada does a lot to support the extractive industry in its overseas operations, but has done little to regulate it. Now, one of the few mechanisms available to hold TNCs, or transnational extractive companies, accountable and for victims to seek redress is through civil suits in Canadian courts. Now, you might ask, why would they want to bring a case in Canada as opposed to the state where the harm happened? And there are a number of reasons why they may not. First of all, the host state judicial system may be corrupt or ineffective. It might not allow class actions. There may be no access to legal aid. And there might also not be lawyers with sufficient experience to bring these complex cases against powerful companies. As well, even if they are able to bring a suit in the host state against the subsidiary of the Canadian company, they may not be able to enforce the suit because transnational corporations are able to move money around and away from that subsidiary, which may mean it might not be able to meet its judgment debt. Now, civil suits, of course, are not a panacea. A plaintiff bringing a claim in Canadian courts faces major legal obstacles before that case can be heard on its merits. And corporations will use all possible means to have the case dismissed before it is heard on its merits, including by bringing a motion, for example, to dismiss the case because the host state, it's argued, is the most appropriate place to hear the case, or to strike the case for failure to close a cause of action. It's very difficult also for plaintiffs to fit human rights violations into a tort. If you have suffered torture, forced labor, slavery, these do not translate well into torts like battery, assault, false imprisonment, or intentional infliction of emotional distress. These torts just don't convey the violence and harm of torture or slavery. Also, corporations have complex structures. Many large extractive companies have hundreds and even thousands of subsidiaries around the world, and these pose unique challenges to holding them accountable. Proving the case is also difficult because the evidence, the witnesses are all in the host state. It's expensive to bring these cases, and there's a significant inequality of arms between plaintiffs and corporations, which have deep pockets and can out-litigate most plaintiffs. Also, you have to find a lawyer willing to bring these claims. In Canada, if a lawyer is working on a contingency fee, the awards may not be very high. And so with the case that could take years, the lawyers may not recover their expenses, let alone the fees. You also need lawyers with sufficient experience because these cases are so complex. Now, most of the cases that have been brought against Canadian extractive companies in Canadian courts for harms caused in other countries have been dismissed on pretrial issues. There have been a few cases that have advanced the law on these issues, making it a little bit easier for plaintiffs to bring these suits. And two of these cases have settled, and so they won't go to the merits, and one may be heard of them on the merits if it too doesn't settle. So even though No plaintiff has yet won a case against an extractive company. And even though there are significant obstacles to bringing these cases, it's still important to bring these cases. If plaintiffs are able to get to the merit stage of a case and win, it can have a regulatory effect on Canadian extractive companies. By exposing them to liability and therefore encouraging them to take meaningful steps to prevent becoming complicit in human rights and violations and environmental harm. It might also encourage the Canadian government to develop a comprehensive regulatory framework to regulate Canadian extractives in their overseas operations. And it might encourage Canada to engage in the ongoing treaty negotiations at the United Nations that would develop a treaty requiring all states to regulate their corporations. Thank you so much for listening to this presentation. If you're interested in this topic of business and human rights, please don't hesitate to get in touch with me. I'd be happy to chat about it. Good luck with your decision making.
Good morning. My name is Tony Van Duzer, and I'm a professor who works on international trade and investment law issues here at the Common Law section. This morning, I want to talk to you briefly about a paper that I wrote with my colleague, the constitutional law scholar, Professor Melanie Mallet, on how to manage conflicts between Indigenous rights on the one hand and Canada's international trade and investment treaty obligations on the other, through a new provision in the Canada-US-Mexico Agreement, the CUSMA, which I'll call the Indigenous General Exception. Now, I think the starting point is that it goes without saying that Canada's international treaty obligations should not restrict Canada's ability to honor its obligations to Indigenous peoples. However, Indigenous peoples have had longstanding concerns about the existence of conflicts between Canadian treaty obligations and the obligations that are owed to Indigenous people under trade treaties like the NAFTA. I think this is especially true in relation to treaty commitments under these treaties to protect foreign investors in Canada. Let me just give you one example of a possible conflict. The government is obliged to consult with and possibly to accommodate any Indigenous group if a natural resource project might affect the group's asserted or proven rights. But if the government imposed new project approval requirements in order to fulfill those obligations to Indigenous peoples, those new provisions cause serious delays or additional expenses related to the project, or even the cancellation of the project ultimately, and there was a US investor in that project, the US investor might be able to claim that the actions of Canada constituted a breach of Canada's obligations under NAFTA to provide fair and equitable treatment to the investor. So the new Canada-US-Mexico Agreement, the CUSMA, is the first Canadian treaty that actually tries to address this kind of conflict through a general exception, which actually protects state actions taken to fulfill legal obligations to Indigenous peoples from challenges based on a breach of treaty commitments. So let me just show you the text of the provision. So here is the full text of the provision, and I want to just emphasize the highlighted part, which is that this agreement does not preclude a party, like Canada, from adopting or maintaining a measure that it deems necessary to fulfill its legal obligations to Indigenous peoples. So what Professor Mallet and I set out to do was to try to figure out how this exception would work, and in particular, how much flexibility it would give Canada to fulfill its obligations to Indigenous peoples. Now, the language of this new Indigenous General Exception borrows heavily from the World Trade Organization's General Agreement on Tariffs and Trade provisions, which provide exceptions for measures taken to protect national security or to achieve important public policy goals like environmental protection or the protection of health. So what we do in our paper is we essentially employ the analytical approach that's been adopted by the WTO dispute settlement panels and the WTO appellate body to analyze the Indigenous General Exception. And what we conclude is that the Indigenous General Exception is likely to afford Canada broad but not unlimited discretion to determine what its obligations require. In order to rely on the exception, Canada would have to show that it acted in good faith. And showing good faith would require Canada to describe a specific obligation to an Indigenous group and then explain how Canada's actions fulfilled that obligation. Canada would also have to show that its actions do not constitute arbitrary or unjustified discrimination or a disguised restriction on trade in goods, services, and investment, as indicated in the first clause of the exception. You can see that on the screen. Well, what does this all mean? Well, because Canada would have to be able to show that its actions met these criteria, Canada's reliance on the exception in a particular case would conceivably be open to challenge by the US or Mexico through the CUSMA dispute settlement process on the basis that of allegations that these criteria are not satisfied. However, the prospect of a CUSMA panel adjudication would raise some concerns. First, panel members are unlikely to be well suited to decide the inevitably complex questions related to what Canada's legal obligations to Indigenous groups are. Most panel members are likely to be non-Canadians who may be trade experts, but they will have likely little expertise regarding Canada's obligations to Indigenous peoples. As well, affected Indigenous groups have no guaranteed right to participate in CUSMA dispute settlement proceedings, unlike the situation, for example, with domestic court proceedings in Canada. What I think is more important is that the extensive, complex, and in many cases evolving and contested nature of Canada's obligations to Indigenous peoples means that Canada needs a high degree of flexibility to decide on an ongoing basis how best to fulfill those obligations. And fundamentally, the requirements of the exception impose some limits on Canada's flexibility in that regard. I want to be clear that the introduction of the Indigenous general exception is a positive development in that it gives Canada added protection for actions that it takes to fulfill its obligations to Indigenous peoples. And it's also true that there are political and other factors that are likely to reduce the risk that the US or Mexico will actually bring a claim to challenge Canada's reliance on the Indigenous general exception. But on the other hand, if a challenge did occur, we conclude that it's hard to be confident that a CUSMA panel would come to the right conclusion regarding whether the exception is available. And if it concludes that the exception is not available, that could risk damaging consequences for Canada's delicate relationship with Indigenous peoples. Well, thank you for your attention this morning, and I hope that you will enjoy the rest of the open house.
Hi, everybody. Thanks for listening to my colleagues as they tell you a bit about the things that they're working on and the things that you might learn about and participate in if you join us here at the Faculty of Law at the University of Ottawa. We're about to move into the virtual fair portion of the program, and but I just wanted to say a couple of things before we do that. So Deborah and at the start, the Dean, and then our panel have, as I have been saying a few times, identified a bunch of things that you might be able to explore if you're with us for your legal education. And there's much more available. And in fact, there's lots of things that you may end up exploring that none of us can even imagine at this time. And an example of that is this very platform that we're gathered together on, and the Gather Town platform that you're participating in, and that the virtual fair is happening in. This was actually put together through a collaboration of our IT and communications staff and law students who were hired as tech fellows. Tech innovation fellows, really. And this was, as you might imagine, prompted by the pandemic and the need for us at the faculty, as well as across the university and other universities across the country, of course, to work out how to keep our programs going online and through the pandemic. And so, as it turned out, we had a bunch of students in our classrooms who were really interested and expert in technology as well, and so we put together a team under the leadership of Ritesh Kotak, and they worked on a bunch of different projects to try to help us as a faculty to really sustain the student learning experience throughout the pandemic. And a bunch of them took on a special project, and one of them, Ryan Mossoff, who is leading this project today, he was really interested in GatherTown and what possibilities it might have. So voila, that led to us trying to work out an opportunity to use that, and we thought that this was a good match of technology and content or objectives, and so here we are in GatherTown. So I thank you for sort of adopting the technology for today to join us here, and so I do want to thank Ryan as the lead on this project, along with the tech fellows working with him. And at the same time, our IT and communications folks, in particular, Eric Prue and Veronique LaRose, for their work in collaboration with the Tech Fellows on this event, and our first year director, Professor Heather McLeod-Kilmurray, who's put in a lot of work into this program as well. I hope you've enjoyed what you've heard and found it interesting this morning. So now the virtual fair is open, and there's representatives of a lot of different things across the faculty. So there's representatives of the admissions team, the career and professional development team. There's representatives of some of the research and advocacy centers, the clinics that have been talked about by the dean and others. I'll be there representing the social justice option, and a bunch of my colleagues will be there either representing particular options or just available to talk to you about things. So you want to get to the virtual fair by moving out of the GatherTown auditorium. You may be in the left or the right or the east or the west auditorium. Move out of that, and then generally, basically, you'll head towards the center and then head north or up on your screen into, there's two rooms for the virtual fair, and there's lots of separate booth areas, and following the instruction sheet that you have, you can approach the booths, and your cameras and audio will activate, and you can talk to whoever's there. And there's also some private rooms, if you're here with a friend and want to chat about things, then you can meet up in places like that as well. So so I invite you to head off into the virtual fair if you haven't already. I'll see you there in a bit, and that we'll keep that going for an hour or so, depending upon how much people want to talk and meet and greet, and then we'll wrap things up. So thanks very much for your patience this morning and being with us, and look forward to seeing you in the virtual fair.